Okay, so we should start, and people can see this. It'll be posted later. So we have the United States of America versus Letitia James. We have limited time. You and I were talking before we invited all our student friends to join us about how a number of people are misunderstanding this indictment. There was a criminal referral from a housing agency with respect to Letitia James a few months ago, and Abby Lowell, Tish James's lawyer, wrote a very forceful defense to the Justice Department. It became public about all the reasons why that case made no sense. That case had no merit. That case should not be brought with respect to a particular property located in the Eastern District of Virginia. And everyone had assumed that that's the property that is at the heart of this indictment, which, by the way, the indictments are getting longer. This one runs to 4 pages as opposed to Comey's 2 pages. Wonder if there'll be an arithmetic or geometric progression in future indictments, but let's put that aside. That is not the property at issue.
No, it's not.
It is not the property relating to her niece. You were among the people who did not get it wrong last night on television as people were breathlessly reporting on the indictment. So why don't we talk about what this indictment actually is, and we'll talk about what it means. We'll talk about the defenses. We'll talk about the weaknesses and what it means for the rule of law. So essentially, the charge is what, Joyce?
So the charge here is bank fraud, which, by the way, is a very serious charge. It's a 30-year felony. Obviously, Tish James, with no criminal history, if she was convicted, would not get that kind of a sentence, but she would have to do prison time. It's a Class A felony. So this is a not fooling around charge when it's brought legitimately.
I'm not sure about the prison time, but we can quibble about that later, given the loss amount.
Well, I mean, it's Class A felony, right? I've litigated that issue. You must do some time in prison on a Class A. The loss amount is very low. It's under $19,000. So I think it's hard to not jump straight into the weeds. So feel free to pull me back out, Preet.
Look, jump. Please jump.
Most districts have these prosecutorial guidelines that say, for instance, we won't do cases where the loss is less than $100,000. We'll refer those to the state or whatever. Sometimes the dollar amount doesn't matter in a case. And here you've got a public official. So maybe you would say it was very important. But boy, this is a piddling little case to be a federal felony, even if you take it at face value. And that, I think, is before we get into the flaws. So this is a third home that Tish James owned. And the argument, as I understand it, that they're making about this property is that she said she was going to occupy it, and instead she rented it. And so over the entire lifetime of the mortgage, which is probably a 20-year mortgage, maybe
20
longer,
or 30 years. So the loss is like
$19,000 over those 2 or 3 decades. And that's what they're calling a felony. They don't, by the way, specify her false statements. There's a second charge that's for the false statements. I've never seen this. They just say multiple false statements. They don't specify them. That's just deficient on its face. And the real issue at the heart of this is they have to prove, not only that she made a false statement, they have to prove that she knew it was false at the time she made it. And it's not enough if down the road she changed the use of the property. It's got to be that when she signed these papers, she knew that statement wasn't true. And of course, anybody who's been through this process understands how incredibly vague all of these standards are.
Yeah.
Secondary versus rental property. Even for me as a lawyer, it's tough to deal with that sort of stuff. I just think it's going to be awfully difficult to prove that what lawyers call mens rea, that she had a criminal state of mind here.
Yeah, so we can look at the indictment itself to see what the charge is. There is the only specificity as to date or to time is the date of the purchase of the home, right? And by the way, $137,000, which is a low price for homes, well above the national average for a home. So we're talking about a small, very modest home. August 17, 2020, it alleges that James purchased a 3-bedroom, 1-bathroom property at this place in Norfolk, Virginia, The loan was originated by a particular financial institution. And she, according to the indictment, was required to occupy and use the property as her secondary residence and prohibited its use as a time-sharing or other shared ownership arrangement or agreement that requires her either to rent the property or give any other person any control over the occupancy or the use of the property. And then it says, this is the punchline, despite these representations, that property was not occupied or used by James as a secondary residence and was instead used as a rental investment property, renting the property to a family of three. There's no time frame given in the indictment as to when it was used for those purposes or when or how long that promise was meant to be complied with. As I understand it, there are documents that suggest sometimes that for the first year or some period of time, just like we have co-ops in Manhattan, if people are familiar with that, there is a period of time during which you make some representation about the use of the property, but then that changes later. And also, of course, it changes. It's harder to prove the intent at the outset if you later decide to use it for some other purpose. And I think it's very peculiar that there's no time frame. And I find it also a little bit peculiar, not peculiar, but if you're going to bring an indictment under a cloud of political retribution, that is the narrative here, and a forceful one, in a public way against a public official, I think you want to say a little more rather than less in an indictment. And you want people to understand, if you're the government, why you win. Now, I've seen some people post like really idiotic statements like, this is an ironclad, airtight indictment. There's no such thing as an airtight indictment. The indictment presents one side of it. There are lots and lots of facts missing. You can have an airtight case at trial, but there's no such thing as an airtight indictment. And there are a lot of details missing, which I don't understand why that would be if you have a strong case, given that there's some interest, you would think, on the part of the government, especially in the wake of the criticism of the Comey indictment, to show you've got the cards, as Trump likes to say.
Yeah, I mean, let's draw the obvious comparison, right? The two federal indictments of Donald Trump, they were speaking indictments. They contained a lot of information. You understood what the government's proof was. You could look at those indictments and say, if the government is able to prove everything that's in this indictment, and that was back in the days where there was still a presumption of regularity, and we assumed that if DOJ lawyers put it in an indictment that it could be believed, you could see how the government was going to prove up its case. That didn't mean, as you say, that it was airtight. You understood the case. I can't look at this indictment and figure out how she got it past the grand jury, to be honest. And maybe the government has great evidence that we don't know about. Maybe whoever she rented to is going to testify, oh, it was a scam from the get-go. But if they had that, I would expect to see it in the indictment. I think what happened, frankly, is you talked about this other charge based on her second rental home that everybody was expecting the indictment would be about. I suspect that Lindsay Halligan, Trump's U.S. attorney in Eastern Virginia, was persuaded that count just wasn't going to fly. And someone, brought out this Hail Mary pass. And because it had not been examined in detail by the professional folks who declined to indict this case, I think they just thought, well, let's just go ahead and do it on this one. And that's both the bank fraud charge and the false statement charge. You say that this indictment is longer, and that's only because Ms. Halligan seems to have learned about asset forfeiture. So there's a criminal asset forfeiture included in this indictment, which means that they will come after Tish James for that $19,000 if they manage to convict her and seize her ill-gotten gains.
I don't ever remember seeing in an indictment out of SDNY a forfeiture notice for this small amount of money.
Never.
Ever.
It costs more to collect it than you take in, right?
We had forfeiture amounts in the hundreds of millions, often billions of dollars. And by the way, you only get to the $18,933 if you consider the life of the loan, as you pointed out, and the loan has only been in existence for about 5 years, according to the indictment. What do you think about the timing of this? I have a different point I wanted to make. The case that was referred to the Justice Department is not the case that was brought.
Correct.
The reason that's significant is that Bill Pulte, the head of the FHFA, when he made that criminal referral and other criminal referrals, including of Lisa Cook, does not shy away from tweeting and posting again and again and again his view of the guilt of the party, his view of the sufficiency of the evidence in a taunting, obnoxious, unprofessional manner. And it's not a small thing. We'll see what happens with this indictment. It's not a small thing that with all that fanfare with respect to that referral by Bill Pulte, a crony of the president, that case didn't amount to anything. So I think it calls into question overall the credibility and professionalism of Bill Pulte. Fair?
I think that that's fair. And I think it's a disturbing fact, a good fact for the defendants, but a disturbing fact that Pulte goes and has a White House meeting with Trump and takes this information over to him and gets him riled up. If you're looking for evidence of vindictiveness and of selectivity and direction to the Justice Department from the president, certainly if there's, and I expect that there will be, by the way, in more than one of these cases, discovery on the issue of vindictiveness, I think that stuff is all fair game.
So there is some speculation that given the reporting and rumors that there were prosecutors, maybe significantly supervisory prosecutors in EDVA, that they thought there was no case against Tish James on any of the properties, and that it wasn't appropriate to go forward, that they may have been on the cusp of writing a declination memo, as we know they did in the Comey case. And there's some speculation, which is not unreasonable, but I want to tag it as speculation, that Ms. Halligan ran prematurely, or at least hurriedly, into the grand jury so that she wouldn't be saddled with a declination memo, which is going to be awkward for them in motion practice and otherwise. Have you heard that? Do you have a view on that?
I have heard that. I don't know whether it's true or not. I just think it makes it even worse for her, right? I mean, there are witnesses who could be called to testify about those facts. Do you think it makes it better that she headed it off? I just think it makes it all look still worse. The real issue in vindictiveness here, by the way, is going to be tagging it up. If the defendants can prove that Donald Trump hated these people and wanted to get them, but if they can't prove that that was actually acted on by the people who were responsible for charging this case, then there's an indication that a motion for vindictiveness might not succeed. But when you've got this whole chain where Trump drops in his chosen U.S. attorney and she's the one going in front of the grand jury and doing it, trying to get around senior career folks in her office, I mean, if this is not a prosecutorial vindictiveness exercise, I don't think that a defendant could ever invoke the doctrine.
I made a point last night, and I wonder if you agree with it, because it occurred to me kind of in the moment.
I didn't see it. I was out having my anniversary dinner as all of this was
unfolding.
Happy
Anniversary.
Thank you.
Happy anniversary. So Jim Comey has made, or his lawyer, my friend Pat Fitzgerald, has indicated, obviously they're going to make a vindictive and selective prosecution motion. Tish James is going to do the same. And the point I was making was, to the extent you were the defense would be, the government's defense of that motion would be, no, it's just purely based on the evidence and the facts and the law, and it's not vindictive. The president's not going after his enemies. To the extent there's another example of an articulated, stated, identified, designated enemy that he's gone after in the space of weeks, that each of these indictments, the existence of them, over the objection of career people, no less, reinforces the claim that the other was vindictive, right? That the more of these you get,
absolutely,
right? So sometimes they say less is more. Sometimes they say more is less in this regard, if that makes sense.
Mm-hmm. I mean, the problem for Donald Trump here is, and look, I don't mean to give him legal advice, but he should just stop talking about it. And the fact that he continues to talk and can't stop,
no,
and that
but
others
do. Let's, in case he's watching.
Yeah, don't take my advice, Donald. No.
Keep talking. And keep DMing publicly.
I love, I don't know if y'all saw that Wall Street Journal story last night saying that the big post on Truth Social where Trump says, Pam, enough already, woman, go and indict my enemies. I'm paraphrasing. But there's finally now reporting that Trump actually misfired. He meant to send that as a DM to her on Truth Social. And I'm so intrigued by all of this because we said at that time that it sounded a lot more like a text message than a Truth Social post.
I wasn't so sure about that, but there's a lot of things that arise from that fact, if it's true.
Well,
First of all, why
I
is he
worry about a
communicating with
president pressing the wrong button. Like, this is a guy who can't get the wrong button, and he's got all the nuclear buttons. It's
Well, I
scary.
think those buttons are probably kept a little bit separate. The push probably not on the iPhone, Joyce. I'm usually with you, but I'm not with you on that one. Um, but why are you communicating by direct message with your cabinet? Number one. Number two, there's a really serious Presidential Records Act violation potential issue. And then third, for vindictive and selective prosecution claim, what's going to happen if it turns out that some of those communications were destroyed? I have no doubt in my mind, I would bet all the money I have, I would bet at least $18,933, and then some, that he's not DM'd a cabinet secretary, including the attorney general, just once in his life. Probably done it a lot. And, we always talk about how, a lot of people talk about how the president of the United States commits his corruption publicly and transparently, and that if there were certain communications that were done behind closed doors or were tried to be kept secret, that would be proof of consciousness of guilt and be evidence of nefariousness. Well, now we may have that.
Yeah.
Now we may have that. And there may be other examples of it. If there are other examples of it that assists a motion for dismissal on these grounds, and if they used to exist and they were destroyed, that gives rise to an adverse inference that such messages existed, and that's also bad for them, right?
Well, it does, and it occurs to me, and I'm just thinking out loud, so I'm not firmly committed yet. But if Trump is persistently using Truth Social, which he owns, for official communications, then I would say, in a sense, those become FOIA-able, FOIA-able records, and some smart reporter, or maybe even just a lawyer who might have an interest in folks that the president could be DMing on Truth Social about, might want to go in with a request for those records, maybe get a lawsuit filed with a preservation order in it to prevent any additional destruction of records. I think that whole thing is just going to be a wide open scandal, and it may be Truth Social that's part of the unwinding of this administration.
So we talk about vindictive and selective. Those are distinct doctrines. They overlap. They're often made together. Jim Comey will make both, according to his lawyer. On the vindictive, there's a long line of statements made by the president about who he doesn't like and who he wants to prosecute and who he wants to put in prison. There's James Comey, Letitia James, and others. On selective prosecution, given that this is one for bank fraud, false statements to a financial institution, also known as mortgage fraud, there is reporting that there are other people in the Trump circle who, at a minimum, you would think have similar facts that would suggest that an investigation is warranted. Bill Pulte, clearly has some tunnel vision. If you look at the referrals that he's made, does she have a more powerful selective prosecution claim than even Comey?
There are cabinet level secretaries who Pulte, or I'm not actually clear, but who we are aware have second homes.
ProPublica published an article.
Is it ProPublica who did? Okay. So that's out there. Cabinet secretaries, similar issues, not indicted. I think that becomes a good selective prosecution argument. I would want to bookend it, by the way, by trying to get information in discovery about cases that this district does not prosecute in this area. I would want to look at declinations in mortgage fraud investigations, because I suspect that, to the extent that there's any case that's similar to this, that those kind of cases wouldn't get prosecuted even if there was evidence, right? Here we're talking about a failure with state of mind and other details. let's just pretend for a sec that the government is able to prove what's in the indictment. I think even then this case is too small, the harm is too attenuated, it's just not a federal felony, and that too would be a factor that would suggest selectivity in this prosecution.
Absolutely. By the way, the other thing that is now clear, I mean, look, I think it's an overused word, watershed. The watershed moment for rule of law in the recent past was the indictment of Jim Comey, because that meant that all the people who said he's not really serious, president's not really serious, he doesn't really mean it. He flails about and he, yells about his adversaries, and he's been doing it for a long time.
Yeah.
And people said, people who were high up in the Justice Department, I know for a fact, went around saying, "You're overreacting." He didn't do anything to Hillary. There was an entire first term, and he didn't do any of those things. So don't worry about it. Well, it's time to worry
Here
about
we
it.
are.
And whether it's because he feels that lawfare was committed against him, and we can talk about that if you want. I think people have this argument all wrong on the other side, but it's now real. And it's not just Jim Comey. It's now Tish James, and there's some other people who are on the list. Trump said a couple of weeks ago, there's no list. You know what that means? There's a list. And when he said this week that the mayor of Chicago and the governor of Illinois should be in prison, that's not an idle threat anymore. It's not an idle threat anymore. When people wonder, well, I'm not Jim Comey, I'm not on the president's bad list. Well, like you may be. And if you're not, maybe your boss will be, or maybe your company will be, or maybe the university that employs you will be, or maybe the school that your kid goes to will be, or maybe the hospital where you want to get care will be, or maybe the research institution that has a cancer trial that you want to get treatment at and maybe save your life or your loved ones, or maybe they will be, right? So this idea that some people I think have, it's attenuated, and I'm not Jim Comey, I didn't piss off the president, misses the point. And the other thing I would say, and I don't think this is an exaggeration, why Republicans should care and why their silence is deafening and really, really, really unfortunate is, how is this going to end? What do you think is going to happen when Trump runs out of Democrats to go after? There are also some Republicans on the list, like John Bolton. At some point, he's going to come after people, whether they're conservative or not, or whether they used to work for him or not, like John Bolton, who he thinks I could just indict them, I could send them to prison. If you have a country in which the sitting president of the United States with impunity can point a finger, whether by DM or otherwise, at any individual, private citizen or elected official or law enforcement official and say, get that person, send them to prison, whether it's a viable case or not, that's going to ultimately affect everyone, even people who think that they're safe now.
And if you're Pam Bondi and it's your Justice Department that's doing it, it's sort of silly to think that you can start drawing lines down the road. How many of these indictments are too many? What if she says at 5, 6, 7, sir, this is enough? She's not going to be very long in that job. Trump has shown that he will find people, no matter how poorly qualified, who will do what he wants done in this area. Lindsay Halligan is a great example. Alina Habba, another great example. A U.S. attorney who said she would use the office to turn New Jersey red once she took over. So there's no shortage of people still that are willing to carry out his plans. I think it's very dangerous, by the way, to underestimate this sort of moment. And I've seen people asking in the chat, well, if the case is so flawed, then how do they get the indictment? And part of the answer is this. The standard for getting an indictment is much lower than the standard for getting a conviction at trial. You just need probable cause, sort of reasonable suspicion that this defendant committed the crime. And in the grand jury process, you have only the prosecutor in there. They may put on an agent to offer summary evidence that's sufficient to provide that probable cause. And the lawyer who's in the grand jury room with the grand jury is, in essence, their legal advisor. So that usually an assistant United States attorney, here a United States attorney, is telling the grand jury, you don't have to find proof beyond a reasonable doubt. That's not what this stage is about. It's about probable cause. And there's no response from the defendant. The defendant does not go in and put on a case unless they're invited in. That didn't happen here. And I think something that's really interesting, and this may be yet another motion that we see from Pat Fitzgerald, perhaps in the Letitia James case, prosecutors do have to advise the grand jury of what's called Brady material. That means exculpatory material that suggests the defendant is not guilty. You do have to advise the grand jury of its existence. Don't know if that happened here. And so if I'm a defense lawyer, given all of the irregularity, I'm going to at least make a pass at having the judge give me access to grand jury transcripts so I can ascertain whether or not that happened. That, again, is something defense lawyers try a lot. It very rarely is the grand jury transcript turned over, but the judge might decide to look at it in camera to see if there's anything worth pursuing.
I think in these cases, the grand jury transcripts are absolutely going to be scrutinized. I think certainly in camera, and probably not just the judge, given the bizarre and extenuating
We should say in
circumstances.
camera means they're not public. It means either just the judge or just the judge and the lawyers see it.
Before we go, can you make me smile by
You're going to make me say it, aren't you?
by reminding us the city in which the house in question in the Tish James indictment is. What's the city?
Now, look, it's the division. The Eastern District of Virginia has got 4 divisions.
But the house, it's in paragraph 1, 3121.
It's in Norfolk, Virginia.
It's in what?
Norfolk, Virginia, where my daddy lived when I was a young lawyer.
From the
No,
north.
it's Norfolk.
Norfolk.
Virginia people, I'm sure I saw some Charlottesville people early on. It's Norfolk, right? Everybody says it
Before we
that way.
went live, I'm like, what is that? Norfolk.
You're just dead wrong on this one.
Look, we need some levity because I think it's actually a very tough time. I don't know how many people appreciate how big a deal all this is and what this means for the degradation of the rule of law. While some people are gleefully announcing this is an airtight indictment. So just say it one more time, Joyce.
Norfolk, Virginia, Preet.
Okay.
You're so bad. And look, by the way, I mean, let me just give y'all a little bit of local color. So I went to law school in Virginia. Oh, look, that Maureen saying, yeah.
Louisville.
This is not a conservative district. Like some people may be assuming that they judge shopped into it. You know, Norfolk is military. Newport News is military. This is a part of Virginia that voted Democratic, voted for Kamala Harris in the last election. So this could be mighty interesting.
Yeah, I still have
correct.
a claim.
Look, 1 million people weighing in. Correct pronunciation.
Okay. How do you say the name of the state that contains Las Vegas?
Nevada. Yeah.
I think the Nevadans say Nevada.
I hear it both ways. One day we're going to do this. I'm going to finally convince you that pronunciation is correct.
No, I do. I like it. I'm going to start saying it that way too. New Orleans. How many syllables does New Orleans have?
It's like 1, right? New Orleans.
I guess. Look, when people ask the question, how is this going to go in a good direction? I think in the immediate term, I think what needs to happen, given the nature of these charges, given the origin of these charges, given the intent and motivation behind these charges, which is utterly anti-democratic and worse, that these cases must, and I think will, the two so far, end in spectacular failure.
Yeah.
And I think they will. And I've gotten the question over the last number of years, which of our institutions is holding up? You have the executive branch, I think, is a problem, and within the executive branch, the Department of Justice is becoming a problem. You have Congress, which is supine. You have the outside of the 3 branches, the fourth estate. I think the press has deep problems. Really, really, our hopes and aspirations for correction lie with the courts. That's why I think, as you and I talk about on the podcast that we do every Tuesday, the Insider podcast, the foundation is being laid to try to undermine the courts. That any minor preliminary ruling at the lowest level of the district court that someone disagrees with, whether it's Mike Lee or Stephen Miller, they say it's a judicial insurrection, or they say it's a judicial. I have an extended set of comments about that we posted on Substack yesterday. But that's why, because that's the remaining bulwark against, the kind of authoritarianism that these people want to impose. Right? They can, so right now they can bring a crappy indictment, they can overbear the will of non-client prosecutors, but they run up against a wall with the court. If that comes down, then we're all doomed.
I think that that's true because I try to always, be a glass half full kind of person. I will say I did see some news this morning that made me optimistic. And it doesn't actually come on the front of these indictments. It comes on the National Guard front. But it's that Oklahoma's governor, who's the head of the Governors Association, actually spoke out against sending Guard troops from one state to another, and specifically from Texas into Illinois. And he did that on a states' rights basis, and made the point that during the Biden administration, we would not have wanted, troops from Illinois coming into Oklahoma. I have long wondered, frankly, about conservative Republicans, states' rights Republicans who've argued for smaller government and less intrusive government, and who have sat back and twiddled their thumbs while Donald Trump jumped all over states' rights principles. Here, finally, a Republican governor has been pushed too far. I hope that will become a trend. Maybe that's something that we can all talk with our elected officials about over the next few days. I certainly intend to engage in my ongoing and very one-sided conversation with my senators.
It's federalism if you can keep it.
Isn't that the truth?
It's a paraphrase. I know you got to go, Joyce. I got to go too. People got to go back to work on a Friday morning. We'll be continuing to follow all developments out of Norfolk.
See, y'all, thank you so much for joining us. We really do value our time with you.
And thanks for paying attention. It's never been more important. Thanks, everybody.